Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the success and failures of others and teach you how to win at the game of intellectual property. Here's the disclaimer. The information I provide on this podcast is for educational and informational purposes only. I am not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. We are on the fourth episode this week. We are talking about what to do if you get a copyright infringement cease and desist letter. So a cease and desist letter can be scary, but they don't have to be the end of the world. Here's what you need to know. It's crucial for small business owners to understand how to respond to cease and desist letters to protect themselves from legal trouble and potential damages. In the United States, we still believe in innocent until proven guilty. For a company to get a judgment against you, they must file a lawsuit, prove that they own the copyright, and prove that you infringed the copyright. There is an industry of harassment, cease and desist letters for copyrights. This industry is looking for easy targets that won't fight back. Unfortunately, small businesses are often targeted. An experienced attorney will be able to assess whether the cease and desist letter is likely a harassment letter or if there is a substantial case and potential for damages. Let me give an example. First example is a small business has a website and a single photo that they thought was in the public domain is put up on the website, and they receive a cease and desist letter based on that photo. Compared with a different example, an employee at your business has been using your internet to download thousands of songs illegally without paying for them and has offered those same files through your internet and allows others to download the songs. They love your company because you have fast internet, and at home they don't. So they do this while they're at work. Hopefully not, but it's possible. Let me explain the ramifications here. When somebody has a registered copyright, and if they're eligible for statutory damages, which means they don't have to prove how much they've been damaged, a judge gets to decide, or a jury, depending on the case, a range between $750 per copyrighted work up to $150,000 per copyrighted work. Now, suppose there are 1,000 songs. That makes the range, if they were to go to court and prove that they own the copyright on 1,000 songs and that there's infringement liability for the 1,000 songs, then the range for that statutory damages is $750,000 to $15 million. This is why there's no one answer to what happens. What do you need to do when you get a cease and desist letter? Some of them need to be treated very seriously. Others, an attorney will help you see, maybe it can be settled fairly easily. Between 2003 and 2008, the music industry sued thousands of individuals for using peer-to-peer downloading services. And for those of you who were using technology before that, it was about 1999 when these file sharing peer-to-peer network services came about. One of the big first ones was Napster, and they allowed people to share the files that they had with others, and Napster would connect those, allow a connection between your computer and somebody else's computer to download or upload. And so that's what they were using to go after individuals. They would look for people that were offering 1,000 songs of titles that were considered copyrighted, and they would send them cease and desist letters. They actually filed a lot of lawsuits, and then it kind of shifted to less lawsuits and a lot of intimidation, a lot of cease and desist letters, and lots of settlements, and also the use of John Doe lawsuits. So a company can record an IP address. They can see, well, we don't know exactly who this is, but we know the IP address. They can actually take that IP address, go to a court, and get a subpoena for the internet service provider to tell them who had that IP address at that time. IP addresses are usually rolling all the time. You don't necessarily have one IP address. You can have that service, but generally your IP address rolls around, but they keep a log of who had it at what exact moment. And so they can subpoena that log and then ask the internet service provider to give them the name. So first they have to file a lawsuit to do the subpoena. So it's a John Doe lawsuit, and it might list 100 different people, basically 100 different IP addresses. They get those IP addresses, then they send a letter saying, we've already sued you. All we have to do is put your name on this lawsuit, which could be considered a shaming technique, because then it's public record. And so they would seek to get settlements that way. So I'm giving this as a history because history repeats itself. And back when these peer-to-peer, that was the precursor to streaming. Now, lots of people pay for streaming services. Popular ones right now are Pandora, Spotify, Apple, Amazon, just to name a few. And so there's lots of these streaming services, and now they have proper licenses. But Napster and these other services showed that there was a real demand for this. And eventually the technology finally worked with the industry, and well, the other way around, the industry finally worked with the technology and figured out, okay, this is what people want, so we're going to deliver it to them. One of the things in our previous episodes, we covered AI, ChatGPT, and other tools that are changing industries, and that there are lawsuits by copyright holders that are trying to slow down and try to keep things the way they are. And so history repeats itself, and we'll see what happens. My prediction is that eventually the copyright holders will figure out how to work with the technology instead of fight the technology. Just like what happened with the peer-to-peer websites and services that the copyright holders finally figured out and stopped fighting the technology and actually embraced it finally. So back to what happens if you've got one of these cease and desist letters. The tactics that were used back then are still used today by some, but the courts going through that, courts really didn't like when it looked like it was just a shakedown. And so what that means is because the courts didn't like it, there are less lawsuits filed now. And what that means is they may just be trying to squeeze you for an easy settlement. They might not actually want to take you to court. And if they don't take you to court and you don't settle, you don't have to pay. Trying to tell the difference, and that is really best left up to an attorney. certainly if you receive a cease and desist letter, and in previous episode, I said, if you're using content on your website, track where you got it, what license you have for it, and that way you can go back and look. If you get the cease and desist letter, you can, look, why didn't this license work? Why am I getting a cease and desist letter for something that I thought was correct? And you can go back and check. But certainly take down the infringing picture. It's usually just one picture, but also when you take it down, either work with a web developer, or if you can do this yourself, make sure there isn't some way that that file can be accessed from your website. So search your website for that exact file and see if it can come up, or work with a web developer to make sure, even though you took it off the main page or whatever sub page of your website, that it's not, that file still available out there. I've seen that as I've helped clients. Work with an attorney. When you work with an attorney, it does two things. One, it sends the message, you are taking it seriously. Then the second thing is that it sends them, it requires them to work with the attorney. They're not supposed to be contacting you after you receive an attorney, or after you hire an attorney and that attorney lets them know, hey, this person's working with me, so don't be talking directly with them. If it's primarily intimidation, that kind of wrecks their strategy, and they might move on to somebody easier. The attorney might be able to negotiate a very reasonable settlement that won't, make you take out a second mortgage on your house. Definitely, each case is different, and you've got to examine each case, and that's best done by an attorney. So thanks for joining us this week. Next week, we are covering the IP ownership, how to maximize your IP ownership, including asset protection expert. We're going to have a guest speaker and we're also going to talk about LLCs, protecting your IP from your employees and contractors. I'm Wayne Carroll with Leveraging Inspiration. Thank you for joining me.
Transactive energy, or I will put it very, very simply, the ability for you to purchase electrical